Define the term acceptance. What are the essential of a valid acceptance? When acceptance by post complete, can acceptance once complete to be revoked under English as well as under Indian law? Indian law. Section 2 clause B. Section 2 clause B define acceptance as when the when the person to whom the proposal is made signifying this assent thereto the proposal is said to be accepted. Proposal is said to be accepted हो गया. Proposal is said to be accepted. A proposal when com- acceptance become a promise. When acceptance accepted become a promise. Acceptance become a promise हो गया. Section 2 clause B. Section 2 clause B define acceptance as when the person to whom the proposal is made signifying this assent thereto the proposal is said to be accepted. Proposal is said to be accepted. Full stop. A proposal when accepted become a promise. A proposal when accepted become a promise. Accepted become a promise. Full stop. A contract involve from the acceptance of in offer. Full stop. Acceptance is act of the assenting act of the ascending by the offer to in offers offer to in offer. Full stop. In other word, it is the external manifestation by the offer of this willingness to be bound by the term of the bound by the term of the officer bound by the term of the offer bound by the term of the offer. Effect of the acceptance to in offer is what a lighted was to in a train of gunpowder. It produce something which cannot be reduced or and on undone. The person making the proposal does not begin bound it until the propose given this acceptance. Full stop. As soon as the proposal is accepted, it become a promise. Section 2 clause B, whereby both the party become legal bound. Both the party become legal bound. Full stop. And after acceptance is given, none of the party can go back as accepted the offer would result in a contract creating obligation for both the party. Creating obligation for the both the party. Full stop. Acceptance may be express or implied. Acceptance may be express or implied. Full stop. It is expressed when it is a communicated by the spoken word spoken or written by doing some required act. Full stop. It is implied when it is to be gathered from the surrounding circumstance or the conduct of the party. Full stop. Conduct of the party. Example in it in auction cell. S is the highest blender. S is the highest bidder. Bidder. Full stop. The auctioneer accept the offer by the striking the hammer on the table. This is in imply acceptance. This is in imply in acceptance. Whoever the offering offering is not bound to accept the offer. Offering Whoever the offering is not bound to accept the offer. Full stop. He is free to reject it or make it to elapse by non acceptance. Full stop. Journal law and Blader Company versus Bharat Cooking Coal Limited 1990. Similarly, a person inviting tender may not accept or reject a bid if in essential condition of the tender is not complained with. Full stop. Case law. Patna Regional Dev Authority. Patna Regional Dev Authority versus Rashtriya Rashtriya Press Nirman Nigam ARA 1966. The tender presented by the first respondent who had been Blacklist for 5 year. Blacklist for 5 year. The tender present by the first respondent. The tender present by the first respondent who had been blacklist for the 5 year was reject as he should blacklist when the tender was to be accepted. Tender was to be accepted. Full stop. It was led that the rejection of the tender was justified and valid. Full stop. The tenders did not challenge this blacklisting when the tender committee decided about this tender. Full stop. Hence rejection of the tender by the tender committee could not be considered to be arbitrary or unreasonable. Full stop. Although acceptance of an offer result in a contract, but in a mere agreement to carry or in agreement to enter into a contract itself does not result in a contract. Full stop. Essential of a valid acceptance. Essential of a valid acceptance of legal rule has to be acceptance. Section 7 acceptance of an offer is the very essence of a contract. Essence of a contract. Full stop. To be legally effective, it must satisfying the following condition. 1. It must be absolute and unqualified. It must be absolute or unqualified. It must be absolute or unqualified. That means it must confirm with the officer. Confirm with the offer. Section 7 clause 1. Section 7 clause 1. In acceptance, in order to be binding, must be absolute and unqualified. Binding must be absolute or unqualified in respect of the all term of the offer, whether material or immaterial, major or minor, a conditional or qualified. A conditional or qualified acceptance is regard not regarded as a valid acceptance. Not regarded as a valid acceptance in offer lapse by rejection or counter offer. Full stop. Therefore, if the party are not ad idem, if therefore if the party are not ad idem, agree on the same things in same sense on all issue relating to the offer and acceptance, is not there is not contract again. There is not contract. Example: A say to B, I offer to sell you my car for 50,000. B reply, I will purchase it for 40,000. Full stop. There is no valid acceptance as it mount to be counteroffer. Case law. यूपी राजकीय निर्माण निगम वर्सेस इंदौर 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 प्राइवेट लिमिटेड 1996. A made an offer to B in the form of the tender. B accept the offer with material change in the offer. Full stop. After that, there was no further communication from A to B. Full stop. The question rose as to be whether silence by A amounting to apply acceptance of the counteroffer. Full stop. It was held by the Supreme Court that when there was a counteroffer, it meant that there was no consequence or a consequence ad idem has to be material term of the contract. Therefore, no concluded contract had come into existence between A and B. 2. It must be communicated to the offer. It must be communicated to the offer to have a valid contract between the party. The sentence must be communicated in some understandable forms. A mere intention to accept with no external manifestation of the do intention to do so, it is not sufficient. Bhagwan Das Kedia Bhagwan Das Kedia गिरधारी लाल, भगवान दास किदा केडा, भगवान दास केडा वसी गिरधारी लाल 1966. For a valid contract, the acceptance must be communicated, and moreover, such communication should be made to the offer. Therefore, I decided to accept your offer, but do not communicate my acceptance to you, or after having decided acceptance, accept your offer. I tell my servant about intention that cannot give rising to a contract. Case law, Felt, Felt House, Felt, Felt House versus Bendil, BINDL, Bendel 1863, Bendel 1863 हो गया. Three, communication must be made by the offeree on offeree over this authority agent हो गया. Case law, वो वोली VOWL वोली वर्सी ली, VO POWL पोली, POWL पोल, POWL पोल वर्सेस ली, पोल वर्सी ली हो गया, पोल वर्सी ली. When communication not necessary, when communication not necessary हो गया, when communication not necessary हो गया, when communication is not necessary, when communication not necessary, when communication not necessary हो गया. Case law, कार्ली वर्सी कार्बोलिक स्मोक बेल, कार्ली वर्सी कार्बोलिक स्मोक बेल 1893, 1893. Mode of the communication, section 2 clause, section 7 clause 2. Mode of the communication हो गया. Section 7 clause 2 provide that acceptance must be according to the mode prescribed over some usual and reasonable mode. Reasonable mode हो गया. Reasonable mode हो गया. It must be 6. It must be given within a reasonable time. Reasonable time हो गया. Case law is Ramsgate Victoria Hotel Co Limited Montefiore example. It cannot be precede offer. It cannot be precede offer. It must be given before the offer come to in and or before the offer is withdrawn. 9. It cannot imply from a silence. So, under what circumstance a proposal and acceptance can be revoked? What are the various modes of the revoking a proposal or sort? Revocation of the offer and acceptance in contract by the post. Revocation of offer and acceptance in contract by the post. It is only after the acceptance of an offer that there rising a contract, and then both the party become bound by their respective promise. After the offer has been accepted, it can be revoked, withdrawn, cancelled. After an offer has been accepted, it remain into a contract, and then it cannot be revoked. It cannot be revoked. Section 4, Alteration. Section 4, Alteration. Alteration C. Revocation mean taking back, recalling or withdrawal. Recalling or withdrawal. Full stop. It may be revocation of the offer or acceptance. Or acceptance. The communication of the revocation is complete. The communication of revocation is complete. Full stop. As against the person who make it when it is put into a course of the transmission to the person who it is made, so as to be out of the power of the person who make it, in against the person to who it is made, when it is come to this knowledge हो गया. Come to this knowledge according to the section 5, a proposal must be revoked at any time. Revoke at any time before the communication of its acceptance is complete, as against the proposer, but not afterward. हो गया. Mode of the revocation of the offer. Mode of the revocation, section 6 deal with the various mode of the revocation of the offer. According to it, an offer is revoked. Revoked offer is revoked